Good morning and welcome to the 12th episode of Gough Square Live. My name is Kate Urell and I'm a barrister here at Gough Square. With me this morning is my colleague Fred Philpott to discuss the Advertising Standards Authority. Fred will need no introduction to many of you, but for those of you who don't know us, Fred was called to the bar in 1974, having previously served in the Intelligence Corps. He is the founder of Gough Square Chambers and a walking encyclopedia of all things consumer law related. He is ranked as a star at the bar by Chambers and Partners, and his most recent write-up is, quote, that he is fit as a butcher's dog, gives a punchy performance in court, and is rightly viewed as the guru. As usual, you can post any questions you have live to the chat room on YouTube, or you can email us at goughsquarevl@gmail.com. That's goughsquarevl, Victor Lima, @gmail.com, and we will deal with those questions at the end of the session. So, Fred, can I ask firstly about the title to this session, Advertising Standards, Authority, ? You don't mean to question the authority of the ASA, do you?
As Kate said, we're happy to take questions through the channel she's indicated. But may I start by asking you a question? Who believes that the Advertising Standards Authority is a powerful organisation acting under statute, imposing sanctions under legislation to police advertising? Well, if you think that, you'd be right about powerful. You'd be right about policing advertisements, but with one exception which I'll come to, it has no base in legislation at all. It is purely a corporate entity which over the years has become very powerful.
Are you saying there is no legislative basis for the ASA then?
Correct, except for the exception regarding broadcasting advertisements. However, we've got to a situation where a High Court judge has referred to, I quote, a public body doing its public duty. One would think of a public body as something set up under statute, but it is not. I think the ASA is a good thing, for reasons I'll come to, but its perceived power does not derive from statute with that exception. It comes from a form of groupthink, rather like some years ago, lots of people said diesel cars are very good, economic, good for the environment, and everyone by and large thought, yeah, they're very good. It's a form of the emperor's new clothes, the old Dutch story where only the little boy says the emperor's naked.
Do you mean no one would dare to say that the ASA has no real authority?
It has authority, but its authority derives from acceptance or acquisition. There are a number of authorities, as we know, such as the Civil Aviation Authority, the Financial Conduct Authority, the Prudential Regulation Authority. And we have statutory agencies, such as the National Crime Agency and the Food Standards Agency. The ASA is not in any of these categories. It is a corporate entity, a company without shareholding, limited by guarantee.
That sounds fairly dismissive.
I emphasise there are many benefits to the ASA, but it is a common perception that the ASA is a powerful statutory body and it has power to, quote, ban, unquote, advertisements. I need hardly give examples, but let's have a topical one. And the one of the latest dictates is about cars, used cars. That if a car has been part of a fleet, then the ASA's view is that by and large this ought to be disclosed to any purchaser. We've had cases in the courts about this, but now the ASA is laying down in effect rules as to what has to be disclosed to purchasers of used cars if the previous ownership has been of a business nature. The media is quite content to go along with this groupthink, saying that the watchdog has banned advertisements or told the advertiser that it may not run that advert again unless it's been cleared by the Committee of Advertising Practice. So there are press suggestions that the ASA ruling might create legal precedents. The origins of the ASA go back to 1961. That was a long time ago, before the breathalyzer, before we abolished capital punishment. And in 1961 was the year that the Secretary of State for War met Christine Keeler. In the intervening years, the ASA has indeed become powerful. In 1961, the trade body, the Advertising Association, established the Committee of Advertising Practice. In the following year, the ASA was set up to regulate the British Code of Advertising Practice. It got some endorsement from the Maloney Committee on Consumer Protection, which said that the concerns of advertising ought to be and can be tackled by voluntary controls, but that depends upon the working of the new scheme and the continued quality and independence of the authority.
Turning firstly to the independence of the ASA then, we know, for instance, that the ASA is funded by a levy on advertising space and paid for by the industry. Does that affect its independence, in your opinion?
The levy is 0.1% of advertising space costs. The levy came into force in 1974 with the creation of another corporate vehicle, being the Advertising Standards Board of Finance, which was said to guarantee the ASA's independence because it does not collect the levy. Well, if someone collects money on your behalf to fund you, that surely by itself does not create independence. But that doesn't matter, because it's never been suggested that the ASA is in the pockets of industry or anything like that. Far from it. Many businesses who are challenged by the ASA about their advertising simply would not appreciate that they have been funding the ASA, which is now challenging them.
So if the ASA is independent of the industry, is it subject to other pressures, for example, of a political nature?
Nearly every organisation is subject to external pressures, be they political, religious, competitors, neighbours, press. Let me give one example. The Wonga advert, which no doubt many people remember, the puppets. It would be possible that the attack on Wonga was in part, albeit subconsciously, motivated by the political pressure, particularly from one member of parliament, against this particular form of payday lending. The situation now with these adverts is that they are only acceptable to the ASA if, instead of saying borrow money and buy a flash TV, it's I need a car to take the kids to school, the boiler's broken down, i.e. essential emergency spending for which the loan is required.
How has this regulation developed over the years?
Well, we've had regulation of advertisements to some extent by statute, but very limited in the Merchandise Markings Act. But in particular, when commercial TV first came into this country in 1955, that was regulated as far as advertising was concerned, and many other things by legislation, and the same applied to the first commercial radio stations in 1973. I'll now come to the bit of statutory law which indirectly gives the ASA some authority. In 2004, the speedily named Contracting Out Functions Relating to Broadcast Advertising and Specification of Relevant Functions Order 2004 was brought in. Under that order, there's a memorandum of understanding. So the ASA is not mentioned in the order, but the Ofcom can delegate certain powers to external bodies, which it's done by this memorandum of understanding. This allows the ASA only to investigate broadcasting advertising complaints. It does not allow them to impose sanctions, which can only be done by passing the matter back to Ofcom. Also excluded are matters such as the prohibition on political advertising and the prevention of unsuitable sponsorship.
So what then are the sanctions that the ASA can impose?
They do not derive from statute, as I keep perhaps labouring the point. Nevertheless, the ASA say, for example, if we have judged an ad has broken the advertising rules, then it must be withdrawn or amended. Anyone reading that would think that the ASA is in a position to impose sanctions, such as a financial penalty, or seek an injunction.
So what in reality then are the sanctions?
One is said to be adverse publicity. We all know the old adage, no, there's no such thing as bad publicity. Of the hundreds and hundreds of rulings, very few get any media attention. They're too boring, frankly. Only those which are somewhat more exciting, such as those relating to sex, get column inches. One example is a Northampton furniture store, which for some 10 years had advertised. The store was named as Sofa King because it sold sofas and other furniture. It advertised as follows: "Our prices are Sofa King low." It took me a few seconds as well. Despite the fact that it had been used for many years, it was ruled offensive. Now I wonder, apart from the 3 people in Northamptonshire who complained, how many people thought, that's a bit of a laugh, let's go and patronise that store. Perhaps an example of no publicity being bad publicity.
But that wasn't a TV or a radio ad, as far as I understand. What the ASA banned in that case was what you see in the picture. So is it right that we're moving from what is actually inappropriate to what is similar to inappropriate? Isn't it a step too far to say, for example, that you cannot juxtapose the words sofa and king?
Well, that was the ruling, and it was accepted. But let's contrast a much more recent one, The Naughty Elf by Poundland. One might think clearly inappropriate, but in fact it was reported that many people thought it was hilarious, and it resulted in the best trading month ever. Other advertising, such as quasi-political advertising, may also produce publicity. One example is the Israeli Tourism Board showed a map of Israel, including the disputed territories. It may be that the publication of such a ruling merely draws attention to the underlying message. Then there is religion. The dismissal by the ASA of a complaint about a bus advertisement which said there is probably no God would have had little impact on whatever people's religious thinking, if any, was, but it would undoubtedly have brought home to some the underlying message of the advertiser.
Fred, we know that the ad alert is the most common form of sanction imposed by the ASA. Does it have any teeth?
This is directed to the advertising industry, and in particular the agencies, telling them not to carry a certain advertisement unless it has been amended or pre-cleared. Again, the effect of this groupthink has been that these orders have to be complied with. One asks what would happen if an advertiser, such as a major supermarket, was told by its agency, sorry, the ASA have told us we can't carry this ad for you. And the supermarket said, well, we'll go elsewhere then. What would the effect be?
But there are indirect powers involved, aren't there?
Ultimately, the sanction is passing the matter to someone else. That is, the ASA can pass matters to a regulator which has statutory powers. In the case of non-broadcasting, this was originally the Office of Fair Trading, who could apply for injunctions under the old Fair Trading Act 1973 and now the Enterprise Act, and also bring prosecutions. With the abolition of the Office of Fair Trading, matters have been dissipated to trading standards departments, the hundreds of them throughout the country, and to the Competition and Markets Authority. Incidentally, that authority has a statutory duty to promote competition, and one finds, for example, in respect of unfair terms, a tendency of rulings to produce a situation where the whole of a certain industry does the same thing, which is hardly promoting competition. Trading standards come into the picture very much, and again, the ASA can pass matters to them. However, these bodies would only take action if they can prove in the courts there's been a breach of the law. Whereas the ASA say we don't get bound by legal precedent or statute, and one has a situation where advertisers or their lawyers say, well, look at this decision of the High Court. Can you put that in front of the council when they make their decision? And that's often said, no, we don't do that. We go on our own rules. But there again, if the matter is then has to be passed to trading standards, for example, to take action, then the courts will decide the matter according to law.
What about broadcast advertisements? Is it fair to say that there is more control in the broadcast sphere?
There is, as I said earlier, the ultimate sanction on the part of the ASA is to pass matters to Ofcom. It's a condition of the standard licence of broadcasters that they will comply with the ASA codes, but it would be Ofcom which imposed the sanction.
Isn't the reality then that an ad will simply not make it into broadcast media, either if it hasn't been cleared by Clearcast or, for example, the ASA has adjudicated against it?
Certainly that is generally the position, but there is this relationship between Clearcast, which is a group of independent broadcast companies' representatives, and the ASA and Ofcom. But one finds generally that matters do get sorted out, and I have to say again, to acknowledge the benefits of the ASA, they will endeavour to deal with things in a cooperative way without necessarily going to formal rulings and so forth.
How have challenges before the courts been received?
Unsurprisingly, there have been a number of challenges by judicial review. The first reported case involved Vernon's in 1993, and most of these have involved the High Court refusing to impose an injunction restraining the ASA from publishing their rulings until the matter had gone to the independent reviewer. The judge in Vernon said it was the responsibility for supervising the industry, and it was a public body with duties to the public to perform those duties. It's a matter of opinion, as I said earlier, whether a self-regulatory body, it can be called a public body. Nevertheless, by agreeing that the ASA is susceptible to judicial review, the ASA is again creating this aura of power.
Can you summarise the overall position on the case law for us, please?
We have distributed a summary of the major cases that there have been over the years with the handout. But just by way of a brief resume, they deal with matters as whether there is a right to an oral hearing in front of the council, no. Whether the ban on a sex education video contravened Article 10 of the Convention on Freedom of Expression, whether there were inaccuracies in reports placed before the council, the role of the independent reviewer, who effectively acts in certain circumstances by way of appeal from the council, although independent is another issue because sometimes there's an interaction with assessors who have been involved. Those and cases involving the translation of scientific reports have all been in front of the court, and with very limited success.
Are there any examples of cases where the advert has been cleared, for example, by Clearcast, but a complaint nevertheless upheld by the ASA?
As I said, the Clearcast ASA Ofcom responsibility has worked well, but there's an analogous case. In the SmithKline-Beecham case, the British Dental Association had approved an advertisement, but the High Court said that was not binding on the ASA, who disagreed. Then another example is an application for judicial review in the Crazy Frog advertisement. Again, this was refused, saying it was a matter for the ASA whether they published their ruling before the independent review. There was a debt-free case dealing with a debt management company, and it was said that only in exceptional circumstances would there be an injunction to prohibit a public body which had embarked on a quasi-judicial task from publishing a decision. So that's going some. Now the ASA is not only a public body, but it acts as a quasi-judicial capacity. The Sainsbury's supermarket case was one aspect of what was called the basket wars. Sainsbury's submitted that a Tesco advertisement was not comparing like with like. This is where a supermarket used to, it's gone out of fashion now, advertise a basket of commodities, groceries, etc., and say that their prices for that basket were cheaper than a competitor. Everyone joined in. It was very, very topical. The independent reviewer said the council had interpreted a rule regarding comparing products meeting the same need or intended for the same purpose in a defensible way, and again, the judicial review application was dismissed.
Are there any examples of judicial review actually succeeding?
One minor success was a High Court decision regarding the opportunity to comment further on what had been submitted to the council, saying there was an arguable case.
Is the message to the industry then to avoid challenging the ASA in the courts?
It seems very clear now that any attempt, save, as was said, in exceptional circumstances, to prevent publication of a ruling is going to fail. Also, by going to the High Court, one is giving publicity, but again, good publicity, bad publicity. We don't know how that did with the Crazy Frog ringtone, but also there's the question of the cost. Sometimes it is better to bury these things.
So in summary, it seems fair to say that the ASA is independent of the industry. It might be subject to some outside pressures, and it is almost undefeated in the courts, which seems quite powerful. Is that a good thing?
In some ways, it's a good thing. It's a good thing because without the ASA, in like the basketballs wars, competition would be conducted through the courts. So rather than going to the ASA about a competitor's advertisement, the industry would be stuck with the civil courts in respect of matters such as slander of title, or going to the criminal courts with a private prosecution. Highly undesirable. Another reason that the ASA is beneficial is that it prevents matters going, in most cases, directly to trading standards with the prospect of a prosecution in the magistrates or Crown Court. It is a filter where matters can generally be sorted out without the intervention of the blunt instrument of the criminal court on a prosecution, for example, under the Unfair Commercial Practices Regulations of 2008. And thirdly, it is a matter of avoiding any form of litigation in respect of decency as far as possible. Dealing with matters such as the naughty elf, etc., if the ASA didn't have this informal self-regulatory power in respect of decency, then we would be back to the undesirable situation of criminal trials for obscenity, such as the Lady Chatterley's case and the school kids Oz.
So if the ASA are keeping issues away from the courts, are they also keeping issues away from the legislators?
Yes, there is the reason it was said that the ASA was originally set up in the early 60s, or one of the reasons, was that the alternative would have been legislation. Going back to those times, we didn't even have the Trade Descriptions Act 1968. We had the Mercantile Markings Acts, which were pretty restricted. Then we had the 1968 Act. Now we've got the 2008 regulations and a welter of restrictions on advertising placed on us primarily from Europe. So that original justification has gone away. But the ASA is expanding its power to the extent of dealing with the advertising of matters such as gender stereotypes. There's to be a consultation following a review, finding that certain depictions were likely to be problematic, such as a woman having sole responsibility for clearing up after the family, or a man failing in household tasks.
But how do you balance that against, for example, the issue that it clearly cannot be right to prohibit showing a woman cleaning, for example? That has to be a step too far.
The answer is said to be that it would not stop the depiction of a woman doing the hoovering, but it mustn't be implied that it is being done because she is a woman. And also, if one did not have adverts for men doing the washing up, then again that would be a factor into whether it was a stereotype form of advertising campaign. One could say the same about men cleaning cars.
And how does that make life easy or difficult, one might say, for the ad agencies and indeed for the lawyers?
Because the ASA do not act on legal precedent, it is more difficult than it is usually difficult to forecast what is the outcome of any particular campaign or industry project. So if those lawyers in the advertising sector are asked to approve an advertisement, Well, it's very difficult because if there's any question of a value judgment, one does not know which way the ASA is going to turn.
Finally, Fred, there are very few sectors which are allowed to self-regulate, but the ASA seems to be going from strength to strength. The numbers of ads amended or withdrawn were up over 88% last year to over 3,000 for the first half of 2017, and the levy was up by 8% to just over £5 million. How, in your opinion, has the ASA survived, and what would you say are the main takeaway points from this session?
The main takeaway points are that the ASA has little statutory base except for investigating broadcasting. But it is a very useful organisation. It prevents almost entirely litigation. And the other main point of today is that whilst we accept the ASA, lawyers in particular should be very wary that they are not a statutory body, so that, for example, if the ASA impose a time limit, we require a reply by so-and-so. It's not like a court deadline. It's not like something you find in the White Book as a date. You can just reply and say, we will do it in 14 days' time. Nor should lawyers allow their clients to believe that immediate adverse consequences will fall on their heads if they fail to respond as required, or even if there is a ruling against them.
So that concludes today's discussion. In the time that we've been on air, we've had a few questions in. Firstly, from Fraser Stephen, asks, do you think it would be unfair to perhaps view the ASA as much like a trade association, in the sense of being a non-statutory dispute resolution process that doesn't necessarily involve trading standards or the courts?
Yes, it originates from the Advertising Association, and one has other examples of self-regulation, and not least of all lawyers and doctors and so forth in the past. One had something called the Finance Industry Standards Association, which was set up by one particular bank in order to bring credit brokers to heel. It was purely non-statutory, but nevertheless, when we were dealing with payment protection insurance, some judges would treat it as if it was a statutory authority. It is a difficult dividing line.
Laura Harcombe is asking, do you think the ASA will ever be made a statutory body?
Well, it's very good to get a question from New Zealand, our solicitor friend Laura. Good evening, Laura. I think the only circumstances in which it would be made a statutory body is if the ASA overstepped itself and really upset a big sector of industry who said to their agency, stop paying the levy. And so the ASA became much less effective. Then there might be a case for government saying, well, we've got to step in and replace it with something under legislation.
And finally, do internet and social media platforms have anything to learn from the ASA?
Certainly, it's been recently reported that Google and Facebook, in order to avoid government regulation, are looking to set up some form of watchdog similar to the ASA in order to police fake news, etc.
It's 11:31, so we've run over slightly. That's all for today. Thank you for joining us. Before we go, I should mention that the next episode of Gough Square Live will air on the 15th of February at 11 a.m, when, in the wake of Lloyd's announcing its ban on customers buying Bitcoin by credit card, Tom Samuels and Anna Medvinskaya will discuss the implications of connected lender liability under the Consumer Credit Act in relation to such cryptocurrency purchases. Thank you for watching.
Thank you.